Hello, my name is Jeffrey Proehl, and I'm a registered patent attorney at the Woods Fuller Law Firm in Sioux Falls, South Dakota. Patent attorneys are registered with the United States Patent and Trademark Office in Washington, D.C., which I will refer to as the USPTO throughout this presentation. Patent attorneys assist clients to navigate the process for obtaining a patent from the USPTO. My goal today is to provide you with some basic information regarding the nature of patents and how one goes about obtaining a patent on an invention. First of all, let's start with the most basic question. What is a patent? A patent is a limited monopoly granted by the U.S. government for a limited period of time. In exchange, the inventor provides a disclosure of the details of the invention, which are made public in the granted patent. Patent rights are granted for a limited time period, usually less than 20 years. Patent rights are not provided automatically, but must be sought from the U.S. government. The next question is often, why do I need a patent? If you are in the business of selling a product or service, and that product or service is covered by a patent, then having a patent gives you the ability to prevent others from competing with your business. As a result, competition from other products and services is reduced or even eliminated. The reduced competition may help you to recoup your investment in developing the invention and the cost of applying for a patent. The reduced competition may even make your business more profitable, even if an inventor is not really interested in producing or selling the invention. A patent may still have value. For example, the patent holder may license or give permission to another person or company to produce or sell the invention. As another example, the patent owner may simply sell the patent outright to another person or company. You should recognize that applying for a patent does not guarantee that a patent will be granted by the USPTO. However, failing to file for a patent in a timely manner virtually assures the inventor that there will be no legal protection against copying the invention by others. Applying for a patent has costs, including government fees, fees for preparing the drawings of the invention, as well as attorney's fees for drafting the application if a patent attorney is employed. Okay, so you've decided that you want to investigate protecting your invention with a patent. Although it is not a legal requirement, the first step is usually requesting a preliminary patentability search of the subject matter of the invention. The results of the search may be considered by a patent attorney to provide an opinion of the potential for receiving a patent on the invention. The results of the search and the corresponding opinion may be used by the inventor as a basis for deciding whether to proceed with the patent process. The purpose of a preliminary patentability search is to locate prior art relevant to the subject matter of the invention. Prior art is the legal terminology used to describe all things known to members of the public prior to the filing of the patent application on an invention. Prior art is considered by a patent examiner in order to determine if a patent can be granted on the invention. Prior art generally does not include information that is not available to the public. Preliminary patentability searches are typically advisory in nature and do not provide a definitive answer as to whether an invention is patentable. What types of inventions are eligible to be protected by a patent? People typically recognize that a patent can protect a machine or a device, but aren't really sure what else might be protected by a patent. Patents may also protect other types of inventions, including methods or processes, chemical compositions, and articles of manufacture, which are typically objects that are not machines or devices. A single invention may have a number of different aspects that fall into a number of different categories protectable by patent. For example, a patent application filed on a medical device invention may include claims directed to the structure of the device, claims directed to a process of using the medical device, and even claims covering the composition of the materials used to form the medical device. If there are different aspects of an invention that can be protected, are there different types of patents? The answer is yes. The U.S. patent law defines a number of different types of patents that may be granted by the USPTO. Utility and design patents may be the most familiar types of patents, with the utility patent being the most common. A utility patent may protect the structure, functionality, composition, or even a process by which a product is made or used. In contrast, the protection provided by a design patent is typically limited to the appearance of a manufactured article. The U.S. patent law employs a first inventor to file system. What this means is that if two different inventors file applications on the same invention, any patent granted on that invention will be awarded to the inventor that first filed an application. The patent law incentivizes filing a patent application as soon as possible. Another significant factor encouraging early application filing is the requirement in the patent law that an application must be filed within 1 year of the first public disclosure of the invention by the inventor. A public disclosure of the invention means disclosing the invention to another person who has no obligation to keep the information secret or offering to sell an embodiment of the invention to another person. A patent application may be filed based upon a conceptual idea, even if a prototype of the invention has never been constructed. However, while it is generally desirable to file an application as early as possible, this desire must be balanced against the need to provide sufficient description of the invention so that a meaningful and useful disclosure is provided in the application. Once an application is filed in the USPTO, no further information about the invention may be added to that application. So you've decided to apply for a patent. How do you go about filing an application? In order to begin the patent application process, a patent application needs to be prepared and then filed in the USPTO. Under the patent law, inventors may prepare and file patent applications themselves on their inventions, or may obtain the assistance of a registered patent attorney or agent. While the inventor may handle the patent application without professional assistance, this approach can potentially lead to problems due to the inventor not fully understanding the patent law. Patent applications generally include a detailed written description of the invention, as well as drawing figures that graphically depict the invention to facilitate the understanding of the written description. The patent application also includes a set of patent claims, which are really the heart of the patent application and the issued patent. The patent claims define what is necessary to be present in a product or service in order for that product or service to be an infringement of the patent. So what actually happens when the USPTO examines a patent application for patentability? Once an application is received by the USPTO, the application is classified by the technology involved in the invention. Once patent examination begins, the patent examiner conducts his or her own search of the prior art related to the invention of the application. The patent examiner determines if the claims of the patent application define an invention that is useful, new, and not obvious in view of the prior art that was located by the examiner's search, as well as any relevant information provided to the examiner by the patent applicant. If the examiner believes that the claims of the patent application do not meet any of these three criteria, the examiner may issue a communication which may include rejections of some or all of the patent claims based upon the prior art. The communication may also include any objections the examiner may have to the form of the application parts. The patent applicant then has the opportunity to respond to the examiner's objections and rejections with arguments and often amendments or changes to the language of the patent claims. These arguments and amendments typically seek to differentiate the invention from the prior art asserted by the examiner in making the rejections. The patent examiner then considers the arguments and any changes to the language of the claims and may continue to reject the patent claims or may issue an allowance of the patent claims. If the examiner issues an allowance, a patent will be granted on the invention. In a general sense, the patent applicant's goal is to have the language of the claims as general as possible to keep the patent coverage as broad as possible. In contrast, the examiner wants the language of the patent claims to be specific enough to differentiate the applicant's invention from what has been disclosed in the prior art. In order to grant a patent on an invention, the patent examiner must be convinced that the combination of elements of the invention set forth in the patent claims are useful, new, and non-obvious in view of what is disclosed in the prior art. Useful merely means that the invention has a use and is not, for example, merely decorative. New means that the invention, as set forth in the patent claims, has not previously been disclosed in the prior art. Showing that an invention is new and useful is usually not that difficult. The third requirement, non-obviousness, means that the invention is not an obvious modification of the prior art or an obvious combination of two or more things in the prior art. Showing that an invention is not obvious is often the most difficult requirement of patentability. The patent law allows a patent examiner to argue that even though the same invention is not identically disclosed in the prior art, it would have been obvious to a person who is knowledgeable in the area of technology to have come up with the invention. Once a patent examiner has reviewed the description and drawings of the patent application and has knowledge of the invention may seem like an obvious solution to a problem. The patent examination process generally does not go beyond the questions of utility, newness, and non-obviousness. Once a patent application has been filed in the USPTO, the patent applicant may begin, or continue, to market the invention. The notation patent pending may be used in connection with a product or service that embodies or implements the invention. The patent applicant does not have a legally enforceable right to stop the sale of similar products or services during the period after a patent application has been filed, but before a patent has been granted. The patent pending label puts others on notice that a patent application is currently being examined by the USPTO. In some cases, the patent pending notification may discourage potential competitors from entering the market with similar products or services. If a patent is granted, the competitor's activities relating to the patented invention will have to be stopped to avoid patent infringement. Once a patent is granted, any products covered by the claims of the patent should be marked with the number of the patent to put others on notice of the patent protection on the product. Marking the product with the patent number may discourage potential competitors from copying a product. It may also affect the amount of potential damages that can be recovered for infringement of the patent. It is often advisable to include the patent number on advertising, promotional materials, and packaging associated with the patented product. Recently, a change in the patent law provides the option of virtual patent marking. Virtual patent marking permits the marking of products with the address of a website where the number or numbers of patents relevant to the product may be listed. Virtual patent marking may be done as an alternative to or in addition to directly marking patent numbers on the product or packaging. Although the USPTO grants patents, the U.S. government does not investigate the actions of others for infringement or enforce patents without the patent owner taking action, such as filing a lawsuit in federal court. When a patent owner believes that a patent is being infringed, the owner may have a patent attorney analyze the allegedly infringing product and compare the requirements of the patent claims with the product to evaluate the strength of the case for infringement. If infringement is believed to exist, the patent owner may notify the alleged infringer in writing of the patent's existence with a request to cease and desist the infringement. The patent owner has the option of filing a patent infringement suit against the alleged infringer if infringement has occurred or is continuing to occur. In a patent infringement lawsuit, a court determines if the allegedly infringing products or activities meet the requirements of the claims of the patent, and if the patent owner should receive any monetary damages. A common question is whether a U.S. patent provides protection of an invention in foreign countries. A U.S. patent may be enforced based upon activities occurring in the United States, but is generally not enforceable with respect to activities that occur in foreign countries. If an inventor desires patent protection in one or more foreign countries, separate patent application filings can be made in the countries where patent protection is desired. Please note that there is no such thing as an international patent. There is a process for filing a single application under the Patent Cooperation Treaty, which may initiate the application process in many foreign countries. But the application process generally must be completed separately in each of the countries where protection is sought. Another common question is, how long does a patent last? In the case of a design patent, the answer is fairly simple. A design patent expires 15 years after the issue date of the design patent, and no fees are required to be paid to the government during that 15-year period in order to keep the design patent in force. In the case of a utility patent, the answer is somewhat more complicated. The term of a utility patent begins on the day that the patent is granted and has the potential to last for 20 years from the effective filing date of the patent application that became the patent. To be clear, the term of a utility patent is not measured from the date that the utility patent is issued, but rather from the filing date of the patent application. As a result, the time that it takes for the USPTO to examine the patent application shortens the potential term of the patent. In order for a utility patent to achieve the entire potential term, the patent owner must periodically pay a maintenance fee to the USPTO to keep the patent in force. If the maintenance fees are not paid, the patent will expire. Hopefully, the information that I provided to you will give you a better understanding of patents and the process for obtaining patents, as well as some reasons why applying for a patent may make sense for you or a business with which you are involved. Thank you for your time.